All right, folks, I'm working on something here. I don't have all the answers, but I think it's very important. I think I have a plan to effectively create the next major step toward nationwide concealed carry. Specifically, I think I have a way to force these terrible anti-gun blue states to be required to issue carry permits immediately upon a person's submission of an application to carry in these states, and not have it dragged on and on and on the way the games are getting played right now by these terrible gun states like New York, California, and so on. Stay tuned. Let me walk through an idea, and then I want to get your responses to it thereafter. Hey folks, I'm Mark Smith, host of the Four Box of Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, folks, so I get a lot of comments from the anti-gun blue states of New York, New Jersey, California, and so on about how these officials are dragging their feet in issuing concealed carry permits in what are supposed to be and are legally required to be shall issue permitting regimes at a minimum. Okay, they can be permitless carry, but certainly shall issue is possible under the dicta of Bruin for the moment. Now, whether or not I agree with this or not, this is kind of the law we're now operating under, and I want to give you a thought about how I think maybe we can improve the situation. Because we understand what's really going on here. In a lot of these places in the blue states, they're basically being told to slow walk the process of issuing a permit. And people are applying for the permit, and the government is sitting on their hands for months and months and months and months, maybe even over a year in some places, before they get to the application, before they give the interview, and so on, okay? Now, I'm not happy with any of this, but this is the world we currently live in, so we have to deal with it. So I have a thought. Now, I don't have it all worked out, but I think I'm onto something here. The way I think this ought to work under the Constitution, I think actually it will work if we get the Supreme Court to address licensing again, and I think they will in the next few years, assuming this Supreme Court stays together, meaning we don't have a replacement from President Joe Biden or Gavin Newsom or whomever. I think the way it should work under the Constitution is this. In those states that have shall issue permitting regimes, well, you fill out that form, which should only be on objective information. Specifically, it really should only ask, are you over 18 years of age? And are you a prohibited person, as those terms are defined by federal statute 18 U.S.C. 922 G 1 through 9 or whatever it is, whatever that number is. And assuming that you're not on, you're over 18 and you're not on that list, you should be able to carry. Okay? But here's the kicker. What's happening, of course, as we know, is the anti-gun gunners are telling law enforcement, licensing divisions, licensing agencies, whatever, to state police, drag your feet, drag your feet, drag your feet, and don't issue the permit until your investigation is done, which could take upwards of a year. But I don't think that's how it should work under the Constitution. I think the way it should work under the Constitution is this. As soon as you submit your application to the relevant licensing authority, and I don't support licensing, but that's where we are, so I'm going down this path. When you submit your application to the licensing authority, representing you're over 18, and you're not a prohibited person, you're allowed to have a gun. You should, at that moment in time, be able to take a copy of your application and treat that immediately as your carry permit. Right then and there. You filed your application. The police have what they need, and that's it. You should be able to start carrying your gun right then and there in public. Your application triggers your right to carry instantaneously. Now, if the police then want to take the next 5 years or a month or whatever it is to investigate you, to check you out, whatever it is that they want to do, running the background checks, fine. Let them waste their time doing it. Because you've already been given the right, because you have the right under the Second Amendment to carry the gun. So if they want to take, waste time on investigating people that are obviously allowed to carry, that's their decision. That's the government's decision. But unless they come back with a reason to call you up and say, we have looked into this and we found out that you're a murderer from last month, and whatever the argument is, you're not allowed to carry the gun, well, then they can pick up the phone, call you, and then they bear the burden of proof that show you don't have the right. But the reason why I like this idea is as soon as you apply, you have the right to carry, using your application itself as the right to carry, is that it takes away the incentive for the police officers and the law enforcement agencies to slow walk the process, because it doesn't do them any good, right? It does no good for them to take 5 years for them to look into your background if you're already carrying. If anything, it actually incentivizes police to speed up the background checks on people, which arguably is good for public safety, right? And then if they've uncovered that someone who's applied is not eligible, well, then they pick up the phone and they call that person up and say, look, we've looked into this. You're not eligible to carry for whatever the reason is. Here it is. But I think this is the way to solve the problem. And I think this is the way we should start to conceptualize the constitutional argument, which again, obviously, I think most of us agree that you shouldn't have to get a license to exercise a fundamental constitutional right. I don't have to get a license to post on X. I don't have to get a license to, exercise my First Amendment rights on a soapbox, on a street corner, expressing my views of the gospel or of politicians. I can talk about my love of Jesus Christ or my views on Judaism, whatever, because I have a First Amendment right to do so. I don't have to get a license to do that. I don't have to buy insurance to get a license to write an op-ed to the newspaper complaining about something. So why do I have to get a license to carry a gun when the text of the Second Amendment says the right of the people to keep and bear arms shall not be infringed? Well, I agree with you that doesn't seem to be the right answer. But that specific issue has not been presented to the U.S. Supreme Court in a direct way. The Bruin case just decided that may issue discretionary licensing regimes is no good. No good. Down the road, maybe they will have an opportunity to discuss whether or not licensing to carry in any respect is constitutional. But we're not there right now. We've got a lot of other issues between now and then to get there, including issues associated with semi-automatic rifle bans, magazine bans, 18 to 20-year-olds being able to exercise their right to keep and bear arms, and so on and so on. So there's a lot of other gun-related issues have to be dealt with first before I think a licensing case gets back up to the Supreme Court. That's just the harsh reality of the situation. But in the short run, I do think there could be constitutional challenges along what I've said, which is, hey, yeah, they have the right to investigate me for the sake of argument, but they don't have the right to delay it. And remember, the Bruin case specifically says that if licensing processes, shall issue licensing processes, start to take up too much money, or they're abused in some way with taking up too much time or whatever it is, well, then could be as-applied challenges. So I think this may be one way to solve the problem, which is the current incentive system that government wants to drag their feet to delay the issuance of carry permits. I think that if you give people the carry permits as soon as they apply, and then the burden's on the government to come back after the fact to try to take that permit away, I think that is a much more intelligent constitutional system. And I think that's where we in the Second Amendment community should be moving towards. Now, as to how this converts into a concealed carry situation nationwide, well, you may have to apply to all the different states, but that won't have to be the case because there's a lot of reciprocity out there. But once you set up the system I have, then it's not clear to me why a resident of one state cannot apply to carry a gun in another state. And that, under the same system I just articulated, if you're let's just say for the sake of argument, you're a North Dakota resident and you apply for a license in New York, it seems to me under my system, as soon as you apply for that New York license, you're eligible to carry in New York. Again, that's not where we are, but that's where I think the litigators and lawyers who are fighting some of these licensing cases ought to be keeping in the back of their minds. Now, of course, in the short run, what you really want to do on the licensing thing is to knock out as many requirements as possible on the grounds that a lot of this information, like mental health records and whatnot, is asking licensing officials to engage in discretionary decision-making, which is absolutely verboten and not allowed under the Bruin decision in the Second Amendment, which even Justice Kavanaugh and Justice Roberts made very clear that these have to be objective criteria. Are you arrested? Have you ever been convicted? What were you convicted? These are black and white questions and answers. They're not fuzziness like whether or not, well, I think you're a person of good moral character, which, of course, a U.S. District Court judge in the Southern District of New York declared unconstitutional just about a month ago there in New York City. So anyway, this is food for thought. I'm still working through these ideas, so I don't have all the answers, but I wanted to share this with you to get some feedback. Let me know if you like any of my thoughts or think there's ways to improve it. I would appreciate it. And again, I hope you learned something here at the Four Boxes Diner. Make sure you share it with your friends and like the video and subscribe if you haven't already. And don't forget to follow me on X at Four Boxes Diner. I get a lot more Second Amendment information out every day in addition to the videos that I do here. So make sure you check out X at Four Boxes Diner, and we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.